I will have you leave.
Fighting for that apartment.
I'm going to ask you to step out of the courtroom.
I'm not stepping out of the courtroom. I would like for you to read the letter.
Well, nothing to see here, folks. Just a judge yelling at a mom. Her son's in hot water. This is Best of the Mess. I grabbed it from my archives from about 2 years ago. Next, after she's done yelling at the mom, you're going to see her yell at the lawyer, and it's really good. So here we go.
May I speak upon what's going on?
Yes.
Okay, thank you. I returned to attest to my animals. After that, I was gone for the night and I was not back. I was gone. Yes, I did tamper with the cameras. They're my cameras as being said before, and I did not have access to them. I did not. You can actually talk through the cameras themselves from the telephone. And again, I did not have access to it. I believe Mr. Burke was actually on point with saying I did not want her essentially seeing what was going on and as I'm trying to get myself together so I can get out of there. I needed my files, all my court information, just like my business information. I needed clothes. I needed things that I needed for myself to take care of myself since I was not going to be at that.
And I understand that, Mr. Bailey Garrison, and that's why the court authorized a civil standby. That's the proper method to go into that home and get your belongings. It's called a civil standby. It was authorized in that order so you could do your things. I wanted you to be able to continue your business. I wanted you to be able to continue to have a relationship with your children. I was trying to be very fair to you, setting bail at an appropriate amount that you could post, that you could go back to your life, but also protecting Ms. Rodriguez.
So I did have note that she was not present at the address at the time. So I did not believe that it was necessary to have Lake Forest Park come out for a civil standby.
I do find that you violated the conditions of the release. I do find probable cause for the charge. You provided a letter and said, I have the information.
That would be great if you could read it, because at the bottom, I understand you say you didn't read it in detail, but it would be great if you would read it. And the only reason I'm saying that is because I understand the position of the court is to protect its citizens, right? But at the same time, the court's responsibility is to protect all of its citizens, okay? You're allowing a situation where my son has maintained his residence for the last 7 years. So putting him in a position where the alleged victim is allowed to remain there without a pot to piss in or a window to throw it out of or a means to obtain said pot.
I have your written statement. I don't want you to speak anymore. That is very, no, you need to stop. I will have you leave.
Fighting for that apartment.
I'm going to ask you to step out of the courtroom.
I'm not stepping out of the courtroom. I would like for you to read the letter. That's what I would like.
I'm going to have you step out of the courtroom if you're going to be inappropriate.
I'm going to allow you to finish. You go right ahead. You're also inappropriate. Let me just say that.
Okay. I'm going to have, ma'am, I'm going to have to find you in contempt if you do not step out of this courtroom.
I'm not in contempt. I'm just asking you to understand, like,
I will read your written statement.
That's afforded to my son as well.
He has an attorney present.
There's no bailiff. There's no bailiff in the courtroom.
You don't want to get a handle on this.
I will.
Miss Newchurch, you're not helping at this point, okay? The judge. Okay. The judge will read. The judge will read your letter if that's okay with your honor. But I don't need you to make
I will definitely read this letter. I am not trying to be unfair to Mr. Bailey Garrison. I have concerns, and these were addressed, and I will read this letter. But I will not have Ms. Newchurch acting like that in court.
Understood. Ms. Newchurch, please keep it down, okay?
Yeah, I will.
Whether or not she's staying in that residence, like the court pointed out earlier, is neither here nor there. That is her address of record. So
that's true.
Yes, and so and I understand that. And if she chooses to stay somewhere else for her own,
they brought a bailiff in. Now it's too late.
For safety, 100%. That is, I am supportive of that because that is, part of her making sure that she herself and her children are safe. But But yeah, and in terms of today's hearing, I don't think there's anything necessary that I need to speak to Mr. Rodriguez on the record about. It's primarily how we're going to proceed with the defendant's situation.
Absolutely. I think going forward, if Mr. Bailey Garrison is able to post bail, whether or not he could go back to the residence was the purpose in my asking those questions.
Certainly. And Your Honor, it doesn't sound, and as far as I can see on her abstracted driving record, her DOL address of record is still that residence. That is, for all intents and purposes, still her address of record, her residence of record. If she's staying somewhere else in the meantime, that's fine. But there's going to have to be a delineation of if she wants to go back and is just too fearful to go back, that's one thing. If she has physically moved out and overtaken her own lease or is, formally changing her address with someone else, that's fine. We'll need to parse that out so that we can amend the no contact order to include that new address that she is at, that he cannot have access to.
My concern is that we have protection for her, whether she wants him to know where she's living.
Correct.
That is something to be considered. And if she wants to keep a private residence, that could be very important. The no contact order is written in a way and that it's whatever school she's at, whatever residence she's at, he's to have no contact. But at this point in time, I'm not clear that Ms. Rodriguez would be safe with that address being disclosed.
I would agree.
So Your Honor, so we're using it. The residence is her DOL address, and that's the address the court is going to be using. It just seems like if this was
Mr. Burke, I think the issue was whether or not she lived in that place, whether her belongings were there. Did she sleep there? Had she been there for an extended period of time? Were her children?
Exactly. So the DOL address is not relevant. It's where she's living. Because if she hadn't updated her DOL address, we wouldn't be using an old address just because that's on the DOL address.
It's just further evidence. You're trying to say because she wasn't on the lease, that means she wasn't living there. I think there are many people that
I'm not saying that at all.
On a lease.
I'm not saying that at all. I'm saying the opposite of that.
You made the argument earlier that she was not on the lease. He was on the lease and not her.
Well, the residence, so are we saying that this is still her residence then even though she's not residing there? Because that's her DOL address.
I'm saying that was her residence at the time of the event. And what I'm trying to say going forward, if she is vacating and has no intention of being there and her belongings are gone, then there is a delineation. But we already have Mr. Bailey Garrison's admissions that he knew he wasn't to be there. He was going to get his things and get out of there. He said on the record he needed to get his files, he needed to get some clothes, and he thought it was okay because she wasn't there at the time. But he understood he wasn't to be there. So that's what we have on the record today from his statements.
He never said that he wasn't allowed to be there, Your Honor. That's not part of his testimony today. So I disagree. She's present. I mean, can we ask her? Are you afraid of Mr. Bailey Garrison?
Objection, Your Honor. To the
so the city can ask questions, and I can't.
No, at this point, the alleged victim is not.
Are you making the decisions, Ms. McDonald, or is the judge?
I'm saying it's not appropriate.
Okay, let's stop this. This is inappropriate. Let's just stop for a moment. We're trying to determine whether or not she was going to be there. So if he's able to post bail, it sounds like she is out of that residence. I will determine right now that she's not going back there. She has said that if you are able to post bail, you can go back to that residence. She is now gone. I do believe that you stated very clearly on the record that when you went back, you were there to retrieve your belongings and you didn't think she was going to be there at the time. It's my understanding that you, from your statements, understood you were not to be there and you didn't think the civil standby was necessary. But you were not staying there.
My client's not going to be answering any further questions.
That's fine. That is for my
what we had said was that we did not believe that she was residing there any longer. That's why he returned to the residence. So this is not his trial, but that's what
his lawyer is saying, oh, it's okay for him to break the court order because she might not have been there. So it's okay for him to break the court order because there was that reason to.
No, it is not. This is whether or not he's violated the conditions of his release.
But that's the reason why is that he did not believe that she was living there based on what she provided to his family. That's what I clearly said. So he does not need to answer any further questions about it. That's why that is our argument, that she was not residing there on July.
He doesn't have to answer any more questions. You're burying him for him. You know the law, sir. You're a lawyer.
The incident was July 3rd. There were 2 days in the interim. She was gone on July 3rd in the evening. So on July 5th, she was not present there. She had already been gone for over a day. That's the evidence that we have today. That's what she just testified to.
I'm finding that he violated the conditions of his release. I am setting the bail. I will leave that bail at $50,000 on the assault and harassment charge.
You're going from $3,000 to $50,000 based on him returning to the place that she was not residing. That's an unfair jump in bail, Your Honor. From $3,000 to $50,000 is not a fair amount of bail for my client.
Your Honor, city's position is that we would ask that the court have the defendant remanded from the courtroom on the court's setting of bail. Again, we would ask for nominal bail on the additional order violation so that he can accrue credit for time served on that matter as well.
And I would ask, Your Honor, if Your Honor is going to find a violation and increase bail, increase it to a reasonable amount. From $3,000 to $50,000, based on the evidence here today, that is not a fair jump in bail. I would ask Your Honor to impose 5, impose 10. He is not going to be able to post $50,000.
I set an amount before that he could make so he could get out to ensure his appearance and to ensure victim safety. And he immediately went back to that residence.
Come on, lawyer. You know better. There is a no protection order where he is not allowed to that residence. It doesn't matter. It doesn't matter if she's there or not there. That means nothing. That has nothing to do with the court order. You're a